Ladies and gentlemen, welcome aboard the Wright Flyer. I'm Randy Wright, and I'll be your captain on this solo flight special edition of our state-of-the-art radio program. Folks, this will be the final boarding call, so if you please, claim your seats, fasten your seatbelts, kick back, relax, and enjoy the show while I go ahead and delve into the pre-flight checklist, as there really is a lot of news and information to get to before I may fully indulge you with your in-flight entertainment. Well, ladies and gentlemen, I know that we've been spending a bit of time evaluating and examining the case of Weinstein, that old movie mogul and filmmaker out of Tinseltown, or the entertainment capital of these United States of America, Hollywood. But there's even an international aspect to all of this that needs to be taken into consideration as well. It turns out that Zelda Perkins, a former assistant of Weinstein, who has come forth breaking her silence, irrespective of the fact that there was a non-disclosure agreement in a settlement that she had with Weinstein regarding these allegations of sexual misconduct, assault, and abuse. She said that it's important that she comes forward and gets her story out, so that other women can be free from having to be exposed to the sort of proclivities, for lack of a better term, that scum like Weinstein engages in. And the important thing about all of this is, when you stop and think about it, the purpose of a non-disclosure agreement in a settlement is to prevent any type of defamation from occurring for either of the parties that come to the table. But what happened in the case of Zelda Perkins and Miramax, which was owned by the Walt Disney Company at the time, is that it created a bit of a loophole. It created something that in many ways could be construed as nothing short of a miscarriage of justice, because it essentially prevented her from going forth and discussing what Weinstein had done. When it comes to the attributes of the law and ensuring that the law is being done in a way that is ensured to protect all parties to it, blind justice, if you will, you have to be able to have non-disclosure agreements. You have to be able to protect oneself or yourself from anyone who would attempt to go beyond the settlement agreement to besmirch your name or to engage in character assassination. But at the same time, you have to recall that a settlement agreement is nothing short of a binding legal contract. And so, when you think back to Constitutional Law 101, for those of you who are unaware, it is impossible to enter into an agreement for an illicit or illegal purpose. Now, the way that legal parlance goes about actually defining what a contract is, there are a couple of elements that you have to satisfy in order for there to actually be a binding legal contract. In other words, you need two parties. One is the promisor, that is the party which makes a promise to do or to refrain from doing something, and the other is the promisee, the one who is seeking a certain benefit. There has to be a meeting of the minds, which means that they have to agree that this is what they are contracting for. In other words, that they have a purpose to which they are entering into a binding agreement which impacts all parties involved. And there has to be consideration, a mutual benefit or detriment to both parties involved. So you have a promise, you have action to the promise, acceptance, and you have to have mutual consideration. But in cases where the contract is for an illicit or illegal purpose, then the contract is non-binding. So that really does sort of raise a legal question with respect to the claims that Zelda Perkins, the former assistant of Mr. Weinstein, if he even deserves to be called Mr. instead of some other term such as scumbag, dirtbag, worthless pervert, those kinds of titles certainly come to mind as an appropriate way to describe what Mr. Weinstein has done and the type of behavior that he has exhibited throughout the years is still binding. Now, I know that I mentioned on yesterday's rather short solo flight special edition of our state-of-the-art radio program here at Radio Aviation Excellence, the Wright Flyer, that Hollywood had a history of including morality contracts within the contracts that they had with various actors and actresses after that very, damaging scandal that occurred with the big comedian of the silent era, Roscoe Fatty Arbuckle, who was on par with Charlie Chaplin, Buster Keaton, Harold Lloyd, and others. And the reason they did that was the studio system wanted to have a modicum of control over the behavioral characteristics and the ability to prevent scandal from basically engulfing the movie-making industry, thereby, exposing it to complete and total collapse as American citizens, and citizens anywhere really, would lash out and refuse to attend the theater as a form of protest, saying that they would not accept this type of outlandish as well as illicit behavior. So we see that there is a history of morality clauses in contracts, but what I've noticed with respect to Harvey Weinstein is that the types of clauses that he had were nowhere in even the league of what I would consider something that would be legally binding, because, again, it's rather seedy what he was attempting to pull off, and it could very well be argued that what he was doing was attempting to contract for an illicit or illegal purpose. And again, that's just not something that we can sit idly by and ignore. If we lose faith in our judiciary and in the legal system, whether it be United States law or, in the case of Ms. Perkins here, the United Kingdom, both the United States and the United Kingdom are what are referred to as common law states, meaning that there is precedent and that we have court law that can alter the way that things are done. It's not just done via a strict legislative code, which is a good thing when you stop and think about it under the totality of the circumstances and with a modicum of objectivity, because that serves to be a standard bearer and protection, a shield, for lack of a better term, for our rights. So it's important that we have that bad law can be overturned by judicious action within the judiciary. But again, it's important that we remember some of the common law traits and tenets that go forth with contracts and torts and, yes, even criminal law, so that when you try and contract for something that is an illegal purpose from the get-go, you cannot have that be a binding legal document. And it makes sense. We don't want to encourage people engaging in illicit acts of illegality. That would be contrary to the entire notion of the old adage which has come to define the land of the free and the home of the brave, that these United States of America are, is a nation of laws and not of men. So we have to have faith in the law, and the law has to serve a just purpose. And again, that ties back into the sagacious advice of that great founding father, Sam Adams, who said that if the United States wished to retain its position as a strong, vibrant, and dare I say robust representative republic, then it is absolutely vital that the American people are a virtuous people. And the only way that we can have a virtuous people, that is, a people that live by a high standard of morality, where we can clearly distinguish and differentiate between that which is clearly right and that which is clearly wrong, is to have the law serve the purposes of justice. True justice, not social justice, as the frothing at the mouth Fabian socialist leftists wish to cram down our throats completely against our will, and certainly without any input on the part of the true ultimate wielders of popular sovereignty in this once thriving and flourishing representative republic of ours, we the people, but actual justice. Justice in which a true sense of fairness based on the abilities of individuals to go forth in equal fashion, opportunity as opposed to equal outcomes, is exactly what we want. That's exactly the sort of thing that we need to be promoting. And that should ring true for legal systems in any part of God's green earth. Of course, that's certainly not the case with respect to Sharia law, which we did a very special episode on quite some time ago. But if you dig through the archives, I assure you, cherished listening passengers and audience members, then it is there for you to find, and that it will be there for you to find for as long as we continue to fly you over the friendly airwaves, leaving you with an indelible yet pure sense of enlightenment, as we always try to here at Radio Aviation Excellence, the Wright Flyer. But again, when you have justice as the centerpiece of your legal system, it follows logically then that you would have it to where you could not contract for an illicit or illegal purpose. So therein lies the concern that comes to my little lawyer pea-brain here with respect to this entire Harvey Weinstein and Tinseltown debacle, because essentially what he was doing here is going forth using an army of lawyers to threaten and intimidate those who had the courage to bring the claims and allegations of what he did to them to the surface, to actually seek a legal remedy against the wrongs that he had perpetrated against them. That is exactly what the legal system's for. But, to my mind, what he has done with this, what I want to refer to as an anti-morality clause in the various contracts that he has entered into and has created during his time as a movie tycoon, mogul, and producer, is that he undermines that. He is abusing it. He is attempting to make it look as though it is legal, as though it fits into the purview of what is accepted and established law, but when you get past the surface of it, when you actually look at what it is doing, you can see that it is not legal, that it does not have legality as its basis. And that is troubling, because that begins to literally work to undermine the faith that the people have in the law. And if the people do not have faith in the law, then the law is not achieving its purpose. It is not creating an orderly society that is as egalitarian as is humanly practicable and possible. Rather, the law then becomes a sword to crush the rights of individuals, to make individuals bow down to the wills of those who are nefarious or are working for deleterious purposes. That cannot be allowed to come to fruition in any free society on God's green earth. That's just a point of fact that should be a self-evident truth. It should be open and obvious. But again, when we delve into this just a little bit further, I'm going to point out some of the statements that draw concerns. It's not that I'm victim blaming here or victim shaming. I'm not. I totally agree with her that what Harvey Weinstein did is deplorable and atrocious. But from a legal standpoint, what I want to ensure is that we maintain a proper balance and that we attack it not based on these altruistic claims or these generalized claims that law is all about money and not based solely on morality. When it comes to contract law, it can't be based on morality alone. Morality is such a wide-ranging thing and can so easily be abused that once again, if it is utilized in a heavy-handed fashion or in a way that is lopsided, if you will, then it is actually working to create an injustice as opposed to serving the ends of justice itself. So let's delve a little bit deeper into what happened here. I'm looking at the Hollywood Reporter over here on my computer that's just outside of screen view. It says that Zelda Perkins, who worked as Weinstein's assistant in Miramax's London office, claims in a new interview with the Financial Times that her boss sexually harassed her and assaulted her female colleague, leading them to a settlement and strict NDA or non-disclosure agreement. Now, typically speaking, whenever you have a settlement agreement with respect to any type of lawsuit that is a civil lawsuit, you will almost always have a non-disclosure agreement. And that makes sense. Because if you don't, then you run into some problems. And let me share a personal story here. My late mother and father, back when they had their practice, had a medical office with one of their colleagues, someone that they had taken care of for years. And he decided that he wanted to evict them, not due to late payments, not due to a delinquency on the lease payments, but because he thought if he could kick them out, he could lease that space at a higher premium. So there was 1 month, 2 years prior to the point that he went forth with the eviction, that he said, all right, I want you out of this space. I don't want to do business with you anymore. And you have 2 days to move out of your office. Now, this is a medical practice. We had patients lined up, appointments to satisfy and fulfill. We had to close them. We had to reschedule all of that. Anyway, I hadn't quite been fully licensed yet when this happened. I was just waiting for the bar results. In fact, it came about a month after this occurred. We went and procured legal services, and my mother, after a settlement agreement had been offered, didn't want to include a non-disclosure agreement. So the attorneys went with that. I was stark raving mad because I knew that if we had to, say, get a loan in order to subsidize the moving process, that would make it nigh impossible, because if the lender called the guy who evicted us, he could go forth and state whatever the hell he wanted. And that's exactly what happened. So you include a non-disclosure agreement with any settlement agreement to protect the rights of all parties involved. Otherwise, you can easily find yourself face to face with an absolute and total miscarriage of justice. And that is certainly something that we should strive to avoid whenever and wherever possible. So, looking back at this, yes, the strict non disclosure agreement is, it is common. But again, it goes back to the point that I stressed just a little bit earlier, that how can it be a settlement agreement of this type if what it is attempting to prevent is illicit or illegal to begin with? Because again, Contract Law 101, prohibits the entering into an agreement for an illegal or illicit purpose. So it says here that, over the past couple of weeks, that dozens of women have come forward with claims against Harvey Weinstein, accusing the veteran film mogul of sexual assault, harassment, yes, even rape. Even rape. So if rape is a part, that is certainly illegal. Rape is a crime of moral turpitude. Many of their stories carry the same details, from hotel rooms and manipulative behavior to intimidation tactics and aggressive cover-ups. And here's where this story is turning on. The fulcrum point of this story is that Ms. Perkins is saying that the way that the strict non-disclosure agreements are operating here is designed to cover it up, is designed to protect the movie industry's interests as opposed to the rights of the staff, personnel, actresses, and what have you that is working under the system. Now, Hollywood has always been a place of loose morals, so to speak. That goes right back to its beginnings in the early silent era. We know this to be the case. We know that drugs, and during the time of Prohibition, that illicit bootleg alcohol were all part of it, and that the actors and actresses were attempting to go from one high to the next high. That is just a part of the systemic culture of Hollywood and the entertainment industry that dates back to its origins and beginnings. It's one of those things that you can't escape. It's been a quintessential aspect of what this industry did time and time again. And Weinstein is but the latest chapter in that ongoing, unchanging conflagration of moral turpitude, so to speak. And it goes on. It says, Zelda Perkins, who worked for Weinstein during his tenure running Miramax Films, answered a question, basically three questions, and essentially what, who wrote this? Let me see. Chris Gardner over at The Hollywood Reporter said is the three questions are, while provoking the same questions, is how much did his assistants know? How tightly wound were their non-disclosure agreements? And where are they now? Well, Perkins came forth. She answered all of them with a bombshell interview that she did with the media outlet, the Financial Times. She is now the first former staffer of Weinstein to come forward and publicly denounce a non-disclosure agreement, shedding light on how Weinstein relied on a network of lawyers to help prevent staffers from speaking out about his alleged bad behavior. So again, if these non-disclosure agreements were designed and implemented in a way as to allow Weinstein to continue with bad behavior, then it is contracting for an illicit or illegal purpose. And yes, there is legal ethics that come into this. For the lawyers that were serving Harvey, and in some cases, I'm assuming the filmmaking studios as well, in the model rules of professional conduct that all lawyers in the United States And there's a similar thing in the United Kingdom, although I have not studied their version of this. If your client is asking you to do something illegal, you can't do it. You tell the client you can't do it, and if the client persists in doing it, you recuse yourself as counsel and you report it. Now, that may sound like it is a breach or client confidentiality, but certainly is not a breach of attorney client confidentiality. That privilege only goes so far as to be legal. And of course, that makes sense when you stop and think about the way that our rights work. Our rights as individual popular sovereigns end where another individual popular sovereign's rights begin. That is just a quintessential aspect of how our legal system has worked for time immemorial. And it is certainly how we want our legal system to continue to work. We do not want to go away from that. We do not want to basically allow willy-nilly whatever to occur, because we need to protect the universal applicability of law and justice in order to ensure that a fair and righteous as well as noble society is allowed to continue. That is what promotes stability within any free system, and therefore it is our duty, obligation, but above all responsibility, and in the case of attorneys, it's our fiduciary duty to ensure that illegality is not allowed to come forth. And that holds true in the English legal system as well, because remember, our legal system has its basis in English common law. Back when we were in our colonial period, that is the type of legal system that we had, and that has heavily influenced the type of law that is practiced here. Now, yes, law is different in England, just as law is different in each of the several states of the United States of America. But the fundamental principles and the foundation of it are all the same. It all has to follow that set standard, that core set of principles, and if it begins to deviate away from that, then we are undermining the central tenet and purpose of law overall. And that is something we can ill afford to do. And that is why there are strict guidelines to this. But, as we all know, there are a great many who claim to be lawyers and attorneys who operate with the same type of mentality that the frothing at the mouth Fabian socialist leftists do, which is, do as I say, not as I do, the rules are meant to be broken, and what have you. I mean, Roger Nash Baldwin, for example, one of the co-founders of the so-called American Civil Liberties Union, or ACLU, is rather infamous for having stated that we will use the Constitution in order to destroy the Constitution. Well, we have a lot of unscrupulous attorneys or lawyers who use the law in a sense to break the law. That's irresponsible. It's destructive. It certainly goes against all the things that we would want to implement in a good and decent legal system, but it tells me, particularly when it comes to the filmmaking industry, that there is a disconnect from the way that things have been done and the way that things should be done in order to ensure that law and justice are served. And part of the whole thing with respect to the natural law tenets, and what you find in the supreme law of the land here, which pursuant to Article 6, Clause 2 of our Constitution, what is known in the common American vernacular as the Supremacy Clause, is none other than our United States Constitution itself being the supreme law of the land, is if the man-made law, or if legislated law, contradicts the natural law tenets that forms the foundation and basis of our entire legal system, then that is null and void. Void ab initio, meaning without the binding legal effect and power of law from the outset. So, when these lawyers, because I'm not going to go out and call them attorneys, attorney is a term that is meant for someone who actually does serve the purposes of the law, does go out of his or her way in order to ensure that the ends of justice are served. They are violating that principle. Why? Because deep down in their heart of hearts, they don't even believe in that principle. They don't believe that that principle should apply. They believe that the law is so malleable that we don't have to follow a set standard. But, ladies and gentlemen, nothing could be further from the truth. Just because certain elements and attributes, as well as aspects of the law, is fluid and constantly changing, the core principles or foundation of it cannot. It must be set in stone. Otherwise, precedent has no meaning, statutory law has no meaning, and justice is merely cast by the wayside. That is, again, something that we can ill afford to allow to come into fruition, particularly in this fast-paced modern society in which we live today. And when we keep all of this in mind, it goes to the deeper purpose of what is happening here is that this leftist mentality has empowered this. It has encouraged scumbags like Harvey Weinstein to believe in their heart of hearts that they can get away with this, that they are somehow above the law. And again, it draws back to that example that I brought up during the course of yesterday's Solo Flight Special Edition of our state-of-the-art radio program, in which I discussed how Harvey Weinstein had in this facility that he was going to for treatment, this therapy place, that he had phone. He had his cell phone. Now that was strictly prohibited for any other people at this retreat. But not Weinstein. For Weinstein, it's always the same. Just as it is always the same for any and every one of these frothing at the mouth Fabian socialist leftists who are hell-bent on completely and utterly annihilating all that we hold near and dear here in the heart of the land of the free and the home of the brave. And that's the type of mindset that has alienated and disenfranchised huge swaths of the American electorate with the modern American system of polity. And in a way, who can blame them? When you see this rank hypocrisy, and yet this holier-than-thou preaching that the frothing-at-the-mouth Fabian socialist leftists engage in time and time again to the point of it reaching ad nauseum, then it's almost as though there is nothing of value in this world. Because, again, it is the selective application and enforcement of the law which ultimately always undermines the faith and belief that people have in the law. And again, that just cannot be workable. It is unworkable. It's unsustainable. It's untenable and unsustainable. But we see here that Zelda Perkins, who had worked for Weinstein during his tenure at Miramax Film, came forth and said that she wants to publicly break her non-disclosure agreement. Unless somebody does this, there won't be a debate about how egregious these agreements are and the amount of duress that victims are put under. My entire world fell in, she says, because I thought the law was there to protect those who abided by it. I discovered it had nothing to do with right and wrong and everything to do with money and power. maybe for unscrupulous attorneys, except that they're not attorneys. If they are that egregious and that unscrupulous, then they are merely lawyers, and bad ones at that. Money and power, it may seem that way in the agreements, but remember, the agreements are voluntary. If you felt that the settlement didn't serve your needs, you go to your legal team and you tell them point blank, this does not represent my rights. I do not feel that it protects my legal interests, and therefore I refuse to abide by this. If you do that, then you open the door to walk back and litigate it. There's always going to be a weighing of options. And you're always going to run a risk if you're going to potentially take this to trial. You have to keep in mind the disparity of money, yes, but that's not the way the law itself is written. You have to be able to have representation that ensures that your interests are protected. And maybe that's what she thought she was going to have, but didn't have, or what have you. And I understand this. To people that are not acclimated to, or accustomed to, or aware of the way that legal parlance and the judiciary works, it can seem alien. It's very ancient. It's laborious. It's monotonous. It's tedious. I get all of that. But I'm a little worried about the characterization here. If her attorneys, quote unquote, again, are they truly attorneys, or are they lawyers masquerading as attorneys, are worth their salt, they would have gone on to say that, the terms of this are unconscionable. We cannot agree to that type of a non-disclosure agreement. Or, if she wanted to go public with it, the way you go public with it is to go to trial. Therein lies the question. Did they have enough evidence to prove it? Here's where it's going to start getting interesting, because I think that is the crux of what is going to determine whether her claims here about non-disclosure agreements are accurate or not. So she goes on to say that her story began 19 years ago when she walked out of Miramax's London office for the last time to see a lawyer with a female colleague. The Financial Times went on to report that Perkins endured sexual harassment while employed as Weinstein's assistant. However, her ultimate exit came after an anonymous female colleague told her that Weinstein had sexually assaulted her. Okay, so again, this kind of falls into the pervasive culture, the pervasive abuses that exist in the movie-making industry, which, by the way, I've demonstrated both on today's Solo Flight Special Edition, as well as yesterday's Solo Flight Special Edition of our state-of-the-art radio program here at Radio Aviation Excellence, the Wright Flyer, that it's been very entrenched within Hollywood's overarching culture to have this sort of nonsense to work in a way that is reprehensible and deplorable, for lack of better terms. But let's see what happens more. Perkins had landed at the Miramax's London office after being introduced to Donna Gigliotti, who had worked for Miramax and later Weinstein and Company, or Weinstein Co. She started in script development, and the paper goes on to report, yet later ended up assisting Weinstein when one of his London-based assistants left their post without explanation. Now, this is kind of interesting on the part of the paper here. It's insinuating. It's insinuating something there. And whether that's the truth or not, I don't know. I'm not going to try and debate that. It's just, I want it to be as factually based as possible. And when you do innuendo and stuff like that, that's where you start to run into the type of sensationalism or yellow journalism or fake news or what have you. I'm certainly not saying that that's the case here. I do believe the claims of Ms. Perkins, but it's a slippery slope, so to speak. Perkins claims that Weinstein exposed himself to her, asked her for massages, and requested that she watch him bathe. The paper quotes her as saying, "This was his behavior on every occasion I was alone with him. I often had to wake him up in the hotel in the mornings, and he would try and pull me into bed." Now, the Hollywood Reporter reports that her breaking point arrived when her colleague was assaulted during a Venice Film Festival back in 1998. The Financial Times has quoted her as saying she was white as a sheet and shaking in a very bad emotional state. "She told me something terrible had happened. She was in shock and crying and finding it very hard to talk. I was furious, deeply upset, and very shocked. I said, 'We need to go to the police.' But she was too distressed. Neither of us knew what to do in a foreign environment," she recalled. Well, therein lies something that kind of worries me a bit. Why didn't she go to the police? Surely there was a way, if you call the police and ask them the procedure, and in London, I mean, they speak English. I mean, I'm not trying to denigrate or take anything away from this victim. It's just these sorts of things are questionable. These are the sorts of questions that need to be addressed so that we can have a more serious conversation about what can and should be done in order to prevent this sort of empowerment of scum Harvey Weinstein from basically being able to occur at any juncture in the future. We have to be cognizant and aware of what could potentially occur from all of this and the ramifications or repercussions that it might have on the legal system for years to come. So the Hollywood Reporter here states that the two sought counsel from London-based law firms Simons, Murrayhead, and Burton, and that the Financial Times reports that they had been advised to seek a settlement claim, and thus negotiation began with international law firm Allen and Overy. The sides agreed upon a sum reported to be 250,000 British pounds to be split between the two women. They signed the contract in October 1998, and consequently, Perkins, who was 24 years old at the time, had not discussed this with Weinstein or even discussed the matter of Weinstein since, until she had granted the interview to the Financial Times. Here's the deal. Yes, her legal counsel advised her that they didn't think they could win, or I'm certainly going to assume that that was the case, but granted, when it comes to law, you can't operate on assumptions. You have to operate on hard, concrete, well-established evidence, and at this current juncture in time, I'm just not seeing that here. And again, this isn't to denigrate her. This isn't to say that she is lying. This isn't to take anything away from what I'm sure was just a horrific and awful experience for her. But we have to look at things from a legal perspective when we're talking about trying to change the law. Non-disclosure agreements, as I have stated throughout the course of today's Solo Flight Special Edition of our state-of-the-art radio program, it's a quintessential aspect of our legal system, whether it be in England or here in the land of the free and the home of the brave. So, it says, Perkins admits that as part of the agreement, she was not allowed to keep a copy of her non-disclosure agreement, but she did turn over to the Financial Times the few pages she was allowed to keep, which detail efforts on behalf of the lawyers to limit or prohibit her participation in any investigations against Weinstein and the film company. Now remember, what I've said since the onset of this program is that Basic Contract Law 101 states that you cannot enter into an agreement or you cannot contract for an illicit or illegal purpose. This part of the agreement is not only unconscionable, it is something that would constitute obstruction of justice. If they had knowledge with respect to his engaging in illicit and illegal activity, or even tortious activity, or criminally negligent activity, you cannot have an agreement that hampers or impedes investigation. That is highly illegal. And therefore, we see that this not only violates the letter of the law, but the spirit of the law as well. And therefore, I don't think it could even be binding in the first place. And that would certainly be if Weinstein attempted to sue her for breach of contract, for going forth with this, breaking or breaching of the non-disclosure agreement. The first thing that I would do if I was her legal representative is I would say, look, this is not only unconscionable, it is contracting for an illegal purpose. That means it was never a valid contract or valid binding legal document in the first place. How do I point it out? Well, with those few pages that she has there, I can point to it. And if it comes to that, I can guarantee you I'm going to subpoena that entire non-disclosure agreement. Because when you are involved in the discovery process and when you are involved in an ongoing litigation, you can subpoena and get access to those documents. So, again, there are protections in place. It's not just about money and power, it's about knowing how the legal system works. And you have to be vigilant and diligent in choosing your legal representation, your legal counselor, so that you ensure that your legal rights and that your best interests are protected at any available given time. That has to be the way it works. Otherwise, you run afoul of it. You run the risk of waiving certain defenses or claims, and you open the door for those who understand how to manipulate the legal system to, at least essentially on the surface, get away scot-free. However, I do not believe that Harvey Weinstein is going to get away scot-free, and I have a feeling that Ms. Perkins would do everything within her power in order to ensure that she got competent legal representation that understood and understands basic contract law. Now, why her attorneys there didn't try and blue pencil that out, that's what we call it in law, to say, during negotiations, I want this part stricken, I want this part changed to this, or altered or amended to reflect or state this particular position. Why they didn't do that, I don't know. But that's certainly something that needs to be addressed. That's certainly a question that I'm not seeing being asked by the rank and file of the graduates of Pavlov's School of Journalism for the salivating mainstream media. No, they're going on this whole thing of we should just get rid of non-disclosure agreements outright. I could not advise that. That would not be advisable. That would be a dangerous precedent if it were to be set, if it were to be established, because then it would undermine the ability to protect people from slander. Because one of the things that you also have to show in a lot of times when you're attempting to recover damages in any type of a civil legal proceeding, you have to prove that you did everything within your power and within reason to mitigate your losses, to mitigate your harm and damages. Well, if you take out non-disclosure agreements, that makes it a bit more difficult, doesn't it? It takes away another legal avenue, and that starts to play into this notion of the Ninth Amendment, at least here in the United States, that you cannot use certain rights prescribed in the Bill of Rights or the first 10 amendments to the United States Constitution, or indeed any amendment to the Constitution, or indeed the Constitution itself, or any law, to infringe upon the rights of others, or other rights contained therein. And in fact, 18 U.S.C. 241 and 242 go to that as well. Deprivation of rights and conspiracy to deprive rights under the color of law. No, you can't have either of those, but that's kind of what the narrative, if we're not careful with it, could lead to. And that would be sort of walking down this little line that Roger Nash Baldwin, the co-founder of the so-called American Civil Liberties Union, or ACLU, did when he said they were going to use the Constitution in order to destroy the Constitution. It is the same type of mentality. It is the same type of mindset, and that is dangerous. Again, we can ill afford to allow that to come to fruition. We can ill afford to ignore the potential long-reaching ramifications that this would have. And so we can't ignore it. We have to address it. Let's see. Perkins admits that as part of her agreement, she was not allowed to keep the copy of it, but she also stated that the agreement included the creation of a complaints procedure at Miramax and for therapy for Weinstein that he would receive for as long as his therapist deems necessary. Further, the agreement called for the appointment of 3 complaint handlers who would be charged with investigating future harassment allegations. If complaints were lobbied against Weinstein within 2 years of Perkins's contract and the complaints resulted in a settlement of either £35,000 or 6 months' salary, Miramax must report the matter to the Walt Disney Company, which owned Miramax at the time, or fire him. Again, if this is illegal activity, let's say it was rape, because there have certainly been accusations of that, it makes it to where this type of agreement, I don't think, should have been considered binding to begin with. Unconscionability is certainly a way to tear down the terms and conditions of contracts. You see it all the time with boilerplate contracts. And you can argue the disparity of bargaining power here would come into play with respect to unconscionability as well. So all of that is something that needs to be taken into consideration. And again, it seems that they are attempting to contract for an illegal purpose, and if that is the case, then it is not a binding legal document. Again, this is Contract Law 101. It's the same here as it is in Great Britain, as it is in any common law country. So Canada, Australia, New Zealand, to a lesser extent Japan, they have kind of a weird hybrid. These principles, these foundations of law, are universal. Why? Because the end purpose and goal of law and the judiciary is the same no matter where you go, except for, again, Sharia laws or where you have dictatorships. But on the surface, even those attempt to claim that they're pushing for some higher purpose, some just purpose. But when it comes to the fundamental principles of it, when it comes to what is applicable, what is highly important, and what matters, those things are concrete. Those things are solid. They do not change. In that sense, they are immutable. Truly and totally immutable. So when we keep all of that in mind, we see that the claims here about maybe doing away with non-disclosure agreements as part of a settlement, that's the wrong avenue or approach. Now, Ms. Perkins stated she had originally intended to expose Weinstein's misconduct, and she stated that she had hoped to go to Disney as part of that effort. But the lawyers were reluctant. They said words to the effect of, "They are not going to take your word against his with no evidence." Again, you have to have evidence. Now, as for the non-disclosure agreement itself, if it was for an illegal purpose, she could get past it. But still, if she didn't have evidence, of course the movie companies, given Hollywood's sordid history, aren't going to listen to her. That's not a law problem. That's a cultural problem within Hollywood itself. That goes right to the heart of the matter. All of these haughty and arrogant actors and actresses and the social elite within Hollywood that attempt to thumb their noses at the rest of us, to those of us who are true dyed-in-the-wool constitutional compositionists, they are the ones that are perpetuating the problem, not the legal system. They're the ones that abuse it, just as they abuse their staff and personnel. If you want to change that, you're going to have to start changing the culture within Tinseltown itself, within the entertainment industry itself. And I certainly don't foresee that happening at any point within the foreseeable future. Hollywood's going to sweep this under the rug. They're going to try and turn this into an identity politics issue where we're pushing for social justice as opposed to actual justice. And so you get a lopsided thing here where it's hit or miss. Again, I am not saying that what she said isn't true, but we have to have the reliance of evidence and proving things with evidence in order to ensure that the litigation and our judiciary is not abused, that it is not utilized in a harass or to engage in illegality. And so you see, folks, it all ties back into the point that I was making right at the opening of today's Solo Flight Special Edition of our state-of-the-art radio program. The law must be for the ends of justice, and that has to be through evidence, and it has to be that you can prove your claims. The burden of proof may shift. If she can prove certain things, or if they had telephone calls, or what have you, then yes. All of a sudden, it becomes much more difficult. And this is part of the thing that I've always tried to tell my friends, family, and loved ones. And I'm going to share this advice with you, our cherished listening passengers and audience members as well. If you are ever in a situation where you're feeling like these things are bad, I know it seems like you can't document it. I know it seems that you can't have evidence, but with the smartphones and everything that we have these days, you can jot down the note, or if you have to, you can record what had happened. You document things in a meticulous fashion, and that way you're protecting yourself. That way you have the evidence. That way, if you have lawyers, and I would suggest attorneys, not lawyers, then that are trying to dissuade you from going forth, saying they won't believe you, then you hit them with the evidence. You say they have to. And if they don't, at least we're taking a stance. Yes, it's risky. But law is not a no-sums game. It is full of risk. And yes, your risks go up exponentially if this is a case that's going to be heading to trial. And so, yes, the lawyers are going to be automatically a little timid or tepid about something that would lead to the continuation of the litigation process, because that could lead to loss. And here's the other thing. Other thing that I thought was kind of interesting here is that it says here she had originally intended to expose, as I mentioned. Lawyers were reluctant, no evidence. And then she said, I was very upset because the whole point was that we had to stop him by exposing his behavior. I was warned that he and his lawyers would try to destroy my credibility if I went to court. They told me he would try to destroy me and my family. Well, look, they can try that, and if they do, guess what? You then turn around and hit him for defamation of character. You hit him for violating the law. There is, and there are, laws on the book for that. Maybe not in England, but you can certainly use a choice of laws clause here. And if they're going after your family that's in the United States, certainly the laws of the United States would work. I mean, that's what in personam jurisdiction, meaning physical jurisdiction, and the idea that you are present in the area where it occurs, and that you did not avail yourselves of the law of a foreign jurisdiction. And in the case of England, that certainly would be a foreign jurisdiction. So, yes, there are avenues there. There are ways to protect yourself there. And I understand that a layperson wouldn't know this. And here is where I think what she ought to be concerned about is, had she received ineffective assistance of counsel? Because that's what it's kind of appearing like to me. That's sort of the message I'm getting from this when I look at it. The threatening of the family, if that's her legal counsel that said that he was going to do that, you combat that. But the other problem of it is, the flip side of it, and again, I'm not attacking her. I'm not saying that she's not credible. But you can't just go and expose things without proof. We have the evidentiary standard to prevent false allegations from occurring. Think back to the Duke lacrosse rape scandal. That turned out to be fake. It ruined the lives of those young men who were falsely accused. And again, that was an overzealous district attorney. Mike Nifong was hardly different than the district attorney in the Roscoe Fatty Arbuckle case and trial and fiasco back in 1921. It's just that one got away with it, whereas Nifong was disbarred and unfortunately jailed just for a few days. He should have been jailed for a lot longer. But we have to follow a system of evidence in our judiciary and our legal system in order to ensure that the rights of all parties involved and that the rights of all citizens are protected. Otherwise, we're not serving the ends of justice. We're turning law into something that is nothing short of a vindictive weapon to bludgeon people. And that, we can't do that. We just can ill afford to do that. Now, what she then says, to avoid that, Perkins said she settled with the agreement as presented by the lawyers. but not before consulting a female American colleague in a senior position whom Perkins said was aware of Weinstein's behavior. That colleague encouraged her to seek a higher sum. At 24 years old in a room full of lawyers, I felt unsupported by my legal team. Looking back, I understand they were following correct practice, but at the time I felt totally isolated. Again, that's her legal counsel failing in their obligations to explain the legal system to her, to explain how it works adequately and efficiently enough so that she has an understanding. And part of our ethical obligations as officers of the court is to go out of our way to try and break down the technicalities of the law, the intricacies of the law, to make it to where our clients understand. And we have to take the time to do that. And it is one of the areas that lawyers receive the most complaints about, or attorneys receive the most complaints about. It's in the area of communication. We can easily break down in the communications. We can easily fail to provide our clients with the sort of legal representation that they need, with the adequate and competent sort of legal representation that they need. And that is unfortunate. And that tells me that there is a failing in the way that law is taught and instructed. I'm fortunate because the law school that I went to focused on that. It was based on ensuring that ethics and morality are part of it. But Perkins then says she wants to shine a light on in which the inequality of power is so stark and relies on money rather than morality. Morality per se cannot be the basis of the law for contracting. It cannot. But again, there are aspects and attributes of it that play in that I explained earlier throughout the course of today's program. Again, you cannot contract for an illegal or illicit thing. You cannot have it be binding necessarily if it is unconscionable. And part of unconscionability is a disparate position in bargaining. But a lot of attorneys are afraid to try and take that fight because they are more concerned about their winning record. That too is not the law so much that is failing, but is a culture that is pervasive in the practitioners of the law, just as there is a culture that is pervasive in the entertainment industry that has been failing these women and victims. And so again, yes, bring light onto it. And I'm glad she did. But I'm also hoping that we see that it's important to be evidentiary. It's important to be fair and equitable in the application and approach of law. Otherwise, then we are creating a miscarriage of justice. We are moving in a direction that is harmful and not beneficial to anyone. And again, that's just something that we can ill afford to allow to come into fruition, particularly in this fast-paced modern society in which we live today. So when we keep these things in mind, we see that follow the law, protect yourself. Know that there are avenues out there. If you're unsure or if you feel that your legal representatives are not helping you, consult others. If people get second opinions for medical treatment, they ought to do the same for the law. And I think that that's an area that could change in the law. If you really want to bring about some changes for this, we need to make it easier to consult with other attorneys so that clients can ask or get a second opinion, because that is not made easily available. And we need to basically make it to where it's easier to understand the law and easier to get access to an understanding of the law And that has been a shortcoming of the law for a long time. Not the law, but the practitioners of the law. It's something that Earl Stanley Gardner, who's famous for creating the whole Perry Mason novels and then later television show, said. It's lawyers do a bad job of explaining the dark arts of the law to good, decent, average, and ordinary citizens. Yes, I feel for what Zelda Perkins went through. And I'm glad she came forth. And I'm willing to bet she will not be hit for breach of this non-disclosure agreement because, as I've explained, you can argue that that non-disclosure agreement was invalid in the first place. And oh, by the way, if Weinstein does file a suit, that's going to be in the public realm. She can certainly go to the media then and can make a public spectacle of it, and that would certainly hurt him because that can then be used against him on cross-examination on any other of the plethora and litany of cases which are mounting against him. So you see, we have to keep all of that in mind. But the main things that we need to take away from this are threefold. Be aware of what's happening around you. Work to establish a fluent and working knowledge and understanding of your constitutional rights and its law in general, and document. If you do those things, it's much more difficult for that type of scenario to unfurl. With that said, it is time for us to begin our descent. I'm going to go ahead and send the flight attendant back with one last round of alcohol. Ladies and gentlemen, she will not force you to sign a settlement agreement as to which type of alcohol you request. And if she does attempt to do that, you have my permission to push her out of the plane. As always, folks, I'm your captain, Randy Wright, and I want to take this opportunity to thank you for flying with us here at the Wright Flyer. Should you have any questions, comments, concerns, or even topic suggestions, please feel free to leave them either here on our YouTube page or on our Google Plus page or even on our Facebook page. And on top of that, I invite you to follow us over there on Twitter with the Twitter handle @RadioAviationEX. One more time, ladies and gentlemen, that's @RadioAviationEX. And there you will find the departure board that lists my personal Twitter account, as well as the personal Twitter account of my first officer, Jeremy Grapington. You will also find the Blogspot account there, which is just chock full of useful information. And then you will find the Cafe Press account, which I'm also going to link in the description section of today's program. There you'll find all sorts of novelty items, trinkets, and goodies, from hats, shirts, shoes, apparels, even pet apparel. Mugs, thermoses, shot glasses, drinking glasses, laptop sleeves and protectors, smartphone sleeves and protectors, stickers, bumper stickers, you name it. Mouse pads even. They're all there at reasonable prices, and you can get them either with the original Radio Aviation Excellence Wright Flyer logo, or our first class passenger logo, or even the two Uplifting America logos, because, ladies and gentlemen, given these turgid and turbulent times in which we live today, America could use some uplifting. And if you haven't already done so, please feel free to subscribe. All subscribers are welcome at Radio Aviation Excellence, the Wright Flyer. We do the show for you. We do the show to empower you. We couldn't do it without you. So please join us whenever you can. As always, I'm your captain, Randy Wright, and I want to thank you for flying with us, and I hope to see you again next time. Please do take care.